Assalamualaikum warahmatullahi wabarakatuh. My name is Nur Dania binti Muhammad Reza and my metric number is 2020891994.
Relevant law that is involved in this case is law of torts negligence. Law of torts is an area of law that protects people.
My name is Mohamed. I'm from class K09 and my student ID is 2020811968.
Assalamualaikum. My name is Amira binti Nasaruddin and my student ID is 2020488146. The appellant, a Form 1 student, was taught agricultural science which entailed practical gardening lessons. On the 15th of March 1971, the appellant sustained injuries from being accidentally struck on the head by a cangkul wielded by a fellow student in the course of the class. He sued the respondents for damages, claiming the respondents failed to take all the proper steps to prevent the appellant under their care from sustaining any injuries. The appellant also claimed that the respondents failed to provide proper supervisions of the students participating in the gardening class. Ajaib Singh J dismissed the suit, holding the respondents had given proper instructions and warnings on the use of the gardening implements and had taken reasonable steps and precautions to ensure safety of the students. Soon after, the appellants appealed and the case was brought to the Federal Court of Civil Appeal. My name is Amira and I will be explaining the facts of this case. In this case, the first appellant suffered an injury when a cangkul wielded by a fellow student accidentally hit his head during the course of a practical gardening lessons. The appellants sued for damages, arguing that the respondents neglected to give adequate supervision and had failed to teach the students the proper use of cangkul. In the High Court, the claim was dismissed by Ajaib Singh J. It held that the respondents had issued proper amount of warnings and directions prior to the use of cangkul and had taken steps and measures to ensure the safety of the students. Hence, the appellants filed an appeal. And next, I will be explaining the material facts of this case. The first material fact is the appellant sustained an injury of 2.5 inches lacerated wound over the parietal bone and a depressed fracture of the same bone. Next, the appellant being underage were owed duty of care by the respondents. It is settled law that a school teacher has a duty to exercise supervision over his students while his students are in the school premises. The third material fact is Mrs. How Kan Yong said she was responsible for checking and distributing the instruments to the students but did not do so on the said morning. The students were left on their own to take the tools from the storeroom and were simply told in a general way to not be near each other and were left to their own devices. And lastly, no explanation was given by Mrs. How Kan Yong as to why at the time of the accident she was not looking at the direction of the class.
Next is parties to the case. The plaintiff is Muhammad, Raihan bin Ibrahim and Anor, while the defendant is the government of Malaysia and ORS.
Now we're going to move on to my part of the assignments and I will be explaining to the class about what is the legal question of this case. So the first legal question of this case is whether or not the defendant owns and in breach of the duty of care to the respondents. And the second legal question in this case is whether or not the respondents was being negligent in doing their work. Moving on to the ratio decidendi. In this case, there are two ratio decidendi in the case, and the first ratio decidendi is the question whether or not the defendant owns and in breach of the duty of care to the respondents. the judge has stated that the defendant, which is a teacher, is not responsible enough to take care of the respondents. It is because the teacher duty is to check the condition of the garden tools, as they are responsible for making sure that the garden tools are safe to use by the students, whereas in this case their teacher failed to do so. However, the judge in charge also stated that the case is very different from the case of the government of Malaysia and others, and Jumat bin Mohamed and another, which has provided a very sufficient supervision and could not prevent the injury, and those behavior were also unknown to the teacher. Still and all, this is a case where a teacher has acknowledged that the boys were handling a very dangerous tools which had not given any sufficient warning as to their use, nor had she taken steps to see that the pupil were positioned within a distance between them as to avoid injury from being inflicted. The second ratio decidendi is whether or not the respondent was being negligent in doing their work. The judge has claimed that the respondent was indeed negligent for failing to take care of all the reasonable and proper steps to prevent the appellant, who is supposedly be under their care, from sustaining the injury.
Relevant law that is involved in this case is law of torts negligence. Law of torts is an area of law that protects people from other people's negligent actions. Its purpose is to make sure that the victim is compensated for any losses caused by the wrongdoer's violation and to discourage them from making the same violation in the future. What is negligence? To prove negligence, we will need evidence that someone owed you a duty of reasonable care and then breached that duty, which caused injuries. There are three elements of negligence, which are duty of care, breach of duty of care, and damage. Duty of care. The defendant owed a duty of reasonable care to the plaintiff. According to this case, the school teacher is responsible for the duty of care of her students. Next, the defendant breached that duty. The respondents were negligent for failing to take all reasonable and proper steps to prevent the appellant under their care from sustaining the injury, and that their teacher did not check the condition of the garden tools nor provided a safe system of holding the gardening class. As a result of the breach, the defendant caused damage to the plaintiff. Appellant, who is a 4-month student, accidentally struck the head by a cangkul wielded by a fellow pupil named Raja Aminuddin bin Raja Ahmad, prosecution witness 3, and thus suffered a 2.5 lacerated wound over the right parietal bone and a depressed fracture of the same bone posteriorly.
Lastly, the court decision, allowing the appeal. In this case, the respondents were negligent for failing to take all reasonable and proper steps to prevent the appellant under their care from sustaining the injury. Moreover, their teacher did not check the condition of the garden tools nor provide a safe system of holding the garden class. In this case, the teacher, appreciating that the boys were handling dangerous instruments, had not given sufficient warning as to their use, nor had she taken steps to see that the pupils were positioned within such distance between them as to avoid injuries from being inflicted. Me and my teammates would like to thank everyone for listening to our group case summary, and we hope that all of you understand the case of Mohamed Raihan bin Ibrahim and Anor and the government of Malaysia and ORS that we presented. Thank you.